Hello everyone and welcome to our webinar on trust deeds. Today Kate Chalker is going to tell us everything that we need to know about drafting trust deeds and what we need to look out and consider when discussing establishing them with clients. For those that haven't been to our webinars before and are joining us live, just a couple of tips on the software that we use. You'll see over on the right hand side of your screen there's a files button. You can click on that in order to download the presentation today. If you need it otherwise, just reach out to us via email and we can send that through to you. The presentation will be recorded and will later be uploaded to our YouTube channel and to our website. So if you do have to leave for whatever reason, or you want to revisit a particular part or show it to somebody else, you're more than welcome, obviously, once that's done. Because it is recorded, obviously we won't do anything controversial in terms of questions. On that point, if you have questions, put them into the chat box on the right hand side of the screen, and we'll get to them as we go through. I'll probably interrupt Kate to ask the questions at an appropriate time, and then we should have time at the end for questions as well. Big presentation today, so I'd like to introduce Kate Chalker straight away to get into it. Kate works with us here in our Sydney office and is very experienced in terms of trust deeds and their drafting. And as I said, is going to tell us everything that we need to know. Thanks, Kate.
Thanks, Adrian. Thanks for the introduction and hello, everybody. As Adrian mentioned, in today's webinar, we will be looking at trust deeds and some of the key aspects to consider when drafting a trust deed or even reading and interpreting a trust deed. Trusts are still very popular in the private sector, and I'm sure there's not a day that goes by in your practice where you don't come across or deal with a trust of some kind. And so being able to both draft and to understand a trust deed is a really fundamental skill. And I'm sure you've heard the saying, read the deed, a million times before, and it might seem a bit cliche, but it really is true, because if there is any legal query that arises in terms of a trust, what the parties are able to do or what they might be entitled to, in most cases, that query can be resolved just by reading the trust deed. Occasionally, it might not be addressed within the trust deed, and that's when you might have confusion between the parties. There might be cause for a dispute, or that might be where the parties have to approach the court for guidance in terms of what to do. So obviously all of those things, the confusion, the disputes, the time in court, we want to avoid as much as possible. So in today's webinar, we will be looking at some of the key things to address to ensure that there is no confusion between the parties throughout the course or throughout the term of the trust. So just in terms of the agenda for some of the things that we will be considering in today's webinar, first we'll be looking at some of the different types of trusts that we have in Australia. What are the key legal requirements that we have for establishing those trusts? Then we'll be looking at the different parties that are involved in the trust relationship and what are the functions of those different roles. We'll be looking at trust property as one of the requirements of setting up a trust. We'll spend some time looking at what are the different powers that the trustee has and what are the rights of the beneficiaries. We'll be looking at how classes, restrictions, and limitations might be used within a trust. We'll be looking at preparing for contingencies, and what I mean by that is what happens when a key person involved in the trust passes away or becomes incapacitated. How can we ensure that we have that succession planning for the trust moving forward? We'll look at some of the key clauses and provisions that we need to make sure we're including within our trust deed. And then to finish off, we will be going through a couple of case studies in terms of poor drafting and the consequences that can arise from that. Okay, so just firstly, a little bit of background in relation to what is a trust and what are some of the misconceptions that may be out there in relation to how they operate. So some people, whether they're lay people or even people practicing in this area, still consider a trust to be a separate legal entity. However, that is not the case. It may be confused by the tax treatment of trusts in terms of a trust being considered a separate taxpayer and needing to lodge a separate tax return. But from a legal perspective, a trust is not a separate legal entity. It is a relationship between the different parties involved. So it's a relationship between the trustee and the beneficiaries and the obligations that are placed on the trustee to look after the trust property for the benefit of the beneficiaries. So it's a relationship whereby the trustee has the legal ownership of the trust assets, but the beneficiaries have the economic or the non-beneficial ownership of those assets. And trusts obviously go back a long way. They go back to the English legal tradition where the courts first began to recognise that where a person is owning property, they're not always holding that property for the benefit of themselves. So sometimes they may be holding property for the benefit of others. And so it is that legal relationship that can give rise to what we know as a trust. And it is that relationship between the three parties, the settlor, the trustee, and the beneficiary. And we'll go through each of those different roles in a bit more detail shortly. So just a bit of a diagram to explain how that relationship does operate. So up the top, we've got the assets, the investments, the trust property, whatever it might be. We've got those assets being owned by the trustee, and that trustee can be an individual or a company. And we've got that trustee managing those assets in accordance with the rules of the trust deed for the benefit of the beneficiaries down the bottom. In addition, we'll also have the role of the principal or the appointor or sometimes even the guardian. And that's where we really do have the control of the trust. Again, we'll come back to that position in a bit more detail later on. But just going back to setting up a trust and some of the reasons why they are so popular and why clients may come to us looking to establish a trust. So firstly, in some situations, it may be necessary to have a trust because the person to benefit from the assets might be a minor, they may be under 18, or they may be disabled. So in some situations, you may need that trust relationship to hold those assets for their benefit because they can't hold them on their own. Second reason is for tax planning and tax flexibility, which I'm sure you are all well aware of in terms of being able to stream income amongst a wide range of different beneficiaries to try and reduce the overall tax that's payable on the trust income. Still a very common and popular thing to do. The third reason, which in most cases is going to be the dominant reason, certainly in our world, for setting up a trust, is for the asset protection benefits that they provide. The law is still very sound in that a person can be, let's say, the sole director of the trustee company, they can be the primary beneficiary, and they can be the principal. But if that individual were to be sued and were to go bankrupt, the law still says that the assets held within that trust do not form part of their personal property. So that's one of the key reasons why we do use trusts so frequently, because our clients can still manage those assets for their benefit and for the benefit of their family members. But if they are in business or they're in a risky profession, if something were to go wrong there, they know that the trust assets aren't going to be exposed. The last reason that we have is to set up a trust to be used in business. I would say that it's probably less common now than it was in the past, particularly with the introduction of lower corporate tax rates. I would say that more people are trading now in a company as opposed to a trust, but some clients do still choose to conduct a business in the form of a discretionary trust, unit trust, etc. So there's some of the different reasons why a client may wish to establish a trust. Okay, next we'll go through the different parties that are involved in the trust relationship. So firstly, we have the settlor, and I'm sure that many of you have been a settlor for a trust in the past. But ordinarily, this is a third party, an unrelated party. Often it's a professional advisor, such as a lawyer or an accountant. And that settlor is responsible for signing the trust deed at the commencement of the trust and also transferring some property into the trust. Because one of the requirements of establishing a trust is that you do have trust property. And in most situations, that initial trust property will be something nominal. It will be a $10 banknote, or it will be a $10 check. And so by signing that check and placing that with the trust deed, that's how you tick off the requirement of having that trust property. But yes, that's the role of the settlor, simply to set up the trust. But moving forward, the settlor should have no involvement in the trust in terms of making decisions, and also shouldn't be receiving any benefits from that trust. The next role that we have is the trustee. And this is a position that has a lot of duties, a lot of responsibilities in managing the trust assets. The trustee can be an individual, it can be multiple individuals, or it can be a company. In most cases, when we are setting up a trust, we will recommend that the trustee is a company. And that's again for asset protection purposes. The reason behind that is that because the trust is not a separate legal entity, if something were to go wrong and a claim were to be made, that claim has to be made against the trustee itself, because you can't sue the trust. And in most cases, the trustee will have the ability to pay any liabilities out of the trust fund or to reimburse itself out of the trust assets. But if we have a situation where the claim is greater than what's actually held within the trustee could be held liable to make up that shortfall. So if we have an individual acting as trustee and they own other assets personally, their main residence, other shares, whatever it might be, those personal assets could be called upon to satisfy the trust liability, which we don't want. So in most cases, some clients will complain about having to set up a new company and the cost that comes with that. But if we do have a brand new shelf company that has $12 in share capital, we're really limiting the exposure there. And so the trustee, I'll go in more detail as to what are their responsibilities, but really their job is to look after the trust assets, to make sure they're being used for the benefit of the beneficiaries, and to make sure that they're complying with the provisions of the trust deed and any relevant legislation. The next role that we have is that of the appointor, the principal, or the guardian. Depending on which trust deed you're looking at, it may have a different name, but really this role is where the ultimate control of the trust lies. And that's because the person that is the appointor or the principal, they have the power to remove and replace the trustee of the trust. And so if the appointor is not the trustee or is not a director of the corporate trustee, and that person doesn't like what the trustee is doing, let's say they're not making distributions to them, then under the rules of the trust, that person would have the power to remove them and to appoint another trustee in their place. So when we are setting up a trust for a client, this is the main question that we're looking for their instructions on. who is going to be the appointor, who do you want to have the ultimate control in relation to these trust assets. Because we know that these trusts can last for up to 80 years, even longer in South Australia, for example, where they have abolished the perpetuity period. So that's a really important question in terms of who's going to bear the ultimate control for the term of the trust. The next position that we have is that of the beneficiaries. I'm mainly referring to discretionary trusts in this webinar. I will go through some of the different types in a second, but certainly when looking at the role of a beneficiary, that's in relation to a discretionary trust. And so these are the individuals, companies, trusts, other entities that can benefit from and receive distributions from the trust. But often you won't just have beneficiaries in general, you'll have them broken down into different classes of beneficiaries. So when we are establishing a trust or reviewing a trust deed, it's important that we understand the difference between the different classes and that we know who is in those different classes. So often you will have the primary beneficiaries being named individuals. That might be mum and dad. And then you will have the general beneficiaries that are normally defined with reference to the primary beneficiaries. So you have mum and dad as primary beneficiaries. And then in terms of the general beneficiaries, it might be the children, grandchildren, great-grandchildren, siblings, cousins, parents, related companies and trusts of them. So you don't need to name and specify every single beneficiary within the trust, but you do need to have some identifiable people, and then you can define the rest of the beneficiaries with reference to them. You may also have within a trust deed income beneficiaries as opposed to capital beneficiaries. And so, as the name would suggest, any income beneficiaries of the trust are able to receive income distributions from the trustee, whereas the capital beneficiaries can receive capital distributions. You may have the two income and capital beneficiaries being the same, or you may have them being different beneficiaries. Certainly in our bloodline trusts, for example, we normally limit the capital beneficiaries to the direct descendants of the primary beneficiaries. However, those capital beneficiaries can also receive income, whereas we limit the income beneficiaries, we expand the income beneficiaries to also include spouses and other family members of the capital beneficiaries. And so that way we can ensure that the capital of the trust remains within the direct family and the direct descendants of the client, but we also have that tax flexibility and that ability to stream income amongst a wider range of beneficiaries. So that's another key thing to look out for. Do we have a difference between income and capital beneficiaries, and who do they comprise? Another different class of beneficiaries you may have or you may not have is default beneficiaries. And so in some trust deeds, it may specify that if at the end of a financial year, the trustee has failed to make a resolution as to who receives the income distributions for that financial year, it may say that the trustee automatically applies or sets aside that income to one or more default beneficiaries. You may not have that provision within the deed, in which case the income would just be accumulated, but of course the trustee would be assessed to that income at the top rate of tax. It will depend on what the client's objectives are in terms of whether you have default beneficiaries or not. If you are definitely wanting to make sure you avoid that penalty tax, if you will, that would be imposed on the trustee, you may look to have default beneficiaries. From our perspective, We often do not include default beneficiaries in our trust deeds, and that's because we're normally looking at these trusts from an asset protection perspective. And so if we do have a situation where we get to 30 June, no resolution is made, and we were to have default beneficiaries that would automatically become entitled to that income, if there were to be a claim made against that default beneficiary, then that entitlement to the income would be a personal asset of theirs, and that is something that could be exposed if they were to go bankrupt, for example. So when we are looking at it from an asset protection viewpoint, we normally don't have default beneficiaries to avoid that income being applied to them. But again, it will depend on what the objectives of the client are. Okay, the next segment of the webinar is how do we actually go about setting up a trust? Now, technically, you don't need a trust deed to set up a trust relationship. However, would I recommend setting up a trust without one? Definitely not, because that's going to lead to far too much confusion and disputes between the parties. So would definitely recommend setting up a trust deed when looking to start a trust. And that would either be in the form of a declaration of trust or a deed of settlement. The difference is you would normally have a declaration of trust where the trust property is already legally owned by the trustee. So if you had John Smith already owning a property and he decided that he wanted to hold that property for the benefit of his children, he could declare that from that day forward, he owns that property or holds that property on trust for the different beneficiaries. And that's when you would have that declaration of trust. On the flip side, and in most instances, you will be going down this latter path. You will just have a deed of settlement. That's where you will have the set law that will set up the trust, put in some trust property, being a $10 check, and then whatever trust property it acquires in the future, whether it's through buying assets in the trust or transferring assets into the trust, that's how you would build up the trust property that way. So yeah, two different ways of establishing a trust. I would say in most cases you will have that normal deed of settlement, and that's what's going to set out all the different rules and obligations for managing the trust assets. I've also got on the slide the importance of having that appointor for ensuring that we know who has the ultimate control of the trust, and just making sure that the set law is an unrelated third party that can't benefit from the trust. That's important for tax purposes. Trust property, again, is one of the requirements of setting up a trust. And there's really no limit on what can be classed as trust property. It's very broad and very wide in terms of the different types of assets that can be held on trust. It could be cash, it could be real property, it could be shares in a public or private company, it could be intellectual property, it could be intangible rights. It's very broad in terms of what can be held on trust. But an important thing to recognize is that it's going to be the trustee that has the legal ownership of those assets. So some people will get confused when they conduct a title search, for example, or an ASIC search, and they see the trustee showing up there with no reference to the trust. And that's because the trustee has the legal ownership of that asset. But when we dig down deeper and look into the trust relationship, we know that it's held by them under the trust relationship for the beneficiaries. I know that in some jurisdictions, Queensland, for example, if you do a title search, it will show the capacity as trustee. But in New South Wales, for example, there's no ability to show that on the certificate of title. So it will just be the name of the trustee or the trustees that are shown as owning that property. Okay, next we'll touch on some of the different types of trusts that we have here in Australia. What are the differences between them? So the first two that I've got there are fixed trusts and unit trusts. You may have unit trusts that are also fixed trusts, but not in all situations. But where you have a unit trust, that's where you don't have discretionary beneficiaries. Rather, you have the unit holders and they have a proportionate entitlement to the income and the capital of the trust. Some of the reasons in which a unit trust may not be a fixed trust is where, for example, the trustee can vary the terms of the trust without the unanimous consent of the unit holders. That would make it non-fixed. If there are multiple classes of units and the trustee has the ability to issue different classes of units, that would make it non-fixed. If the trustee can make gifts or if it can redeem the units for less than market value, they're some of the indicators that can make a unit trust non-fixed. Because to be a fixed trust, you really need that fixed proportionate entitlement, that absolute entitlement to the assets of the trust. And most of the time when we are establishing a fixed trust or converting a trust to be a fixed trust, we're normally doing it for land tax purposes to get the benefit of the land tax threshold. The next type of trust that we may come across is a testamentary trust. And that's to be compared against an inter vivos trust. Inter vivos is a trust established during a person's lifetime, whereas a testamentary trust doesn't come into existence until the will maker passes away. So a testamentary trust is set up under a person's will and doesn't come into existence until they pass away. In most cases, a testamentary trust will be discretionary in nature, but that's not mandatory. You can actually have a testamentary trust that has unit holders, that has fixed entitlements, but that will all be set out within that person's will. So you'll have quite a long will because it's including a trust deed, essentially, setting out all of the rules and provisions that govern that trust. Next type of trust we have, and probably the most common, is a discretionary trust. Some people refer to them as a family trust. And that's where the trustee has a wide and unfettered discretion in terms of who is to receive the income and who is to receive the capital from the trust. And they are widely used for tax flexibility purposes and also for asset protection, because when it comes down to it, the discretionary beneficiaries only have a right to due administration of the trust. So the trustee has to follow the rules of the trust, and also they have the right to be considered for a distribution. But they're really the only rights that these discretionary beneficiaries have, which is why they're so popular in terms of asset protection. You may also have a hybrid trust, for example, a hybrid unit trust, and that's where you're combining the features of a fixed and a discretionary trust. So with a hybrid unit trust, you would still have unit holders that would have a proportionate interest to the trust assets, but the trustee may also have the discretion to make income distributions to a wider range of beneficiaries. You may also have a charitable trust. So if you are setting up an entity with a charitable purpose and you want to have that registered as a not-for-profit entity to get the benefit of the different tax concessions that exist, that can be done in the form of a trust as well. A couple more: superannuation funds. They are also a type of trust, whether that's a retail fund or a self-managed super fund. There's still that trust relationship because you still have the trustee managing those superannuation proceeds for the benefit of the members. And that's why we can't deal with a superannuation fund under a person's will. We need to make that death benefit direction to the trustee, because it is held outside of a person's estate. Last but not least, you may also have a bare trust, which is essentially where you have a single beneficiary that retains all of the control with respect to the trust assets. You may use a bare trust if we're doing a limited recourse borrowing arrangement for superannuation purposes, for example, but that is another type of trust that exists. Okay, the next part of today's webinar, we'll be looking at, we've looked at the different roles within a trust. What are some of the different rights and responsibilities that attach to those positions? So firstly, the most onerous position that we have is that of the trustee. So the trustee needs to make sure that they are following the provisions of the trust deed and that they're looking after the trust property for the benefit of the beneficiaries. They need to make sure they're acting honestly, reasonably, and in good faith. They need to make sure they're preserving the trust assets and avoiding the wastage of those assets. So that's why we often see the need for a trustee to maintain insurance over the trust assets. We need to make sure, if we're acting as trustee, that we're following the income distribution clauses, following the capital distribution clauses, whether that's on an ad hoc basis or on the vesting of the trust. The trustee needs to exercise care and diligence at all times, avoid any conflicts of interest that it may have, and also to maintain proper accounts, because we know that from a tax perspective, the trust does need to lodge a tax return, and we may also have financial statements prepared for the trust. Now, there's obviously a lot of responsibilities that come from that position. If there were to be a breach of those duties, it will depend on what is contained within the trust deed and also the nature of that breach. For example, it may say within the trust deed that the trustee won't be held liable if the breach was they were not acting dishonestly or negligently, whereas if it was negligent or dishonest, there may be further consequences for the trustee in having breached those duties. On the flip side, so obviously a lot of responsibilities, but there also are a few rights and powers that the trustee will have in acting in that role. And again, these are all supposed to be set out within the trust deed. Ideally, the trustee will have a wide range of powers to allow it to best manage the trust assets. For example, it should have the ability to sell the trust property, to discharge liabilities that arise from the trust out of the trust fund. It should have the ability to borrow against the trust assets. The trustee should also have the ability to be indemnified and reimbursed out of the trust fund. Like I mentioned earlier, because the trust is not a separate legal entity, the liabilities are incurred by the trustee itself. But if the trustee is carrying out its responsibilities properly and in accordance with the deed, it should be able to reimburse itself out of the trust assets. The trustee should also have the ability, if there is uncertainty or confusion, it should have the ability to apply to the court for guidance on certain trust questions. If we then look to the beneficiaries of a trust, in terms of their responsibilities, they really don't have any, because like I mentioned, all they have is the right to be considered for a distribution and the right to due administration of the trust. But if we do have a responsible beneficiary that wants to know what is going on with the trust and wants to make sure that the trustee is fulfilling its role properly, it should be asking questions, making sure that it understands the operations of the trust. So, for example, the beneficiary should be finding out what is the purpose of the trust. Is it carrying on a business? Is it investing in real property? What is the intended purpose? Are there any limitations that we have on the trustee's powers? What are the beneficiary's rights, both under the trust deed and under the legislation? How are the trust assets being managed? And ideally, it would be good if the beneficiary knew a little bit about trust accounting and also the principles of trustee administration. But really, in terms of the beneficiary responsibilities, there aren't any. And it wouldn't be uncommon for there to be many beneficiaries of a trust that don't even know that the trust exists. Because you have such wide-ranging classes of beneficiaries, that would not be uncommon at all. Also, in terms of rights, to try and gain all of that information, they do have the ability to ask for financial records, etc., from the trustee so that they can inform themselves as to what's in the trust and how are those assets being managed. But ultimately, again, they have the right to be considered for a distribution. But if the trustee ultimately decides that, no, we're not going to make any income distributions to this beneficiary this year, then so be it. That's the way that a discretionary trust operates. And of course, if the trustee is not complying with the trust deed and the beneficiaries think that the provisions have been breached, the beneficiaries would have a right to recourse against the trustee for those actions. Okay, the next part that we'll consider is really the importance of making sure that we have an appointor and that we have some succession planning in that role. Because we do have this trust that can go on for up to 80 years, it may be the case that the appointor that's originally nominated is not there at the end of the trust period. So we need to make sure that there's mechanisms for that person to be replaced. And there's a few different ways that this can be actioned within the trust deed. Normally you'll have a combination of all of these, but it's important that we have a way of appointing someone else to that role should the first person pass away or become incapacitated. So the first way in which you can ensure you always have an appointor is simply name them in the deed. So when you establish the trust deed, you can have a first principal or appointor, and that's the person that will hold the role from the establishment of the trust. And then you can also appoint successor appointers, so that on the death or the incapacity of the first principal, the other named people will take over that position. You can also have it so that the principal can appoint their successor under their will, and you would normally specify that within the trust deed. We don't normally recommend that this is how you carry out the succession, just because people have the ability to change their wills whilst ever they have that testamentary capacity. So there's always a risk that if you prepared your will today and you were thinking about the appointor and so you included it then, but you might then go and change your will 10 years down the track and you simply forget to address it. If that were to be the case, then you would be missing out on that succession planning. So we would normally recommend that we have a separate deed prepared. And that's the fourth bullet point that I've got on the slide, in that during the period of the trust, the appointor should have the ability to nominate someone else on their death or incapacity. It may also be specified within the deed that if there is no one that has been nominated under a deed or under the first principal's will, it may revert to their legal personal representative, so their executor under their will. That's always an option, but that may not be the best way to carry out that succession planning. There's a case study, which I'll come to a bit later, which looks at that issue. Another way, if you do have joint principals or appointors, you will normally want to specify that if one of them passes away or becomes incapacitated, that you've got the survivors or the survivor that can carry on without that person. You may also have temporary succession. So you may also have it built into the deed that you can have a temporary appointor if someone were to be ill for a period of time, or even if they were going overseas and not able to fulfill that role, you might have an appointor for a temporary period. But normally you will have a combination of all of these different approaches to allow for that flexibility. But a really important part of a trust deed is ensuring that we do have an appointor at all times, so there's no confusion as to who maintains the control. Another really important aspect of setting up a trust is ensuring that we have a variation power. These trusts can go on for 80 years and a lot can change within that period. You might change the trust purpose. There might be people that enter into the family, or there may be falling outs within the family. And so there's people that you want to include or exclude. Often there are changes in legislation, particularly in tax legislation. And so the trustee really needs the ability to be able to amend the terms of the trust many, many years down the track. For example, with the recent land tax surcharge for foreign beneficiaries that has been introduced, if there wasn't a variation power contained within a deed, that would have caused a lot of issues, because the only option in that case would have been to apply to the Supreme Court to have the deed varied. So obviously we don't want to incur the time and the expenses involved with that. So we want to have a broad variation power so that we can ensure the trust is able to meet its purpose and its objectives across the 80-year term. We also need to be careful more when we're interpreting a trust deed, that we're looking out for any conditions or any requirements for exercising that power. For example, do we need to get the written consent of the principal? That's always something that we need to make sure we're ticking off. And another thing to consider is just making sure that if we are varying a trust, that we're not causing a resettlement. So that's effectively where you change the trust so much that it's treated as the existing trust being terminated and a new trust being established. And if that were to occur, it could lead to a whole lot of CGT and also stamp duty implications. So important to make sure that we have a broad variation power, and that if we are looking to exercise that we're not triggering any kind of resettlement. Okay. Just a few provisions, going over some of the concepts that we've discussed before, but some of the key provisions that we need to make sure that we're including or that we're addressing when we review a trust deed. So firstly, in terms of the beneficiaries, if we are using it for asset protection or tax flexibility, we want to make sure that we have wide classes of beneficiaries. That will include new people that are born into the family or even married into the family in the future. We want to make sure that we can identify them, and also looking at, do we have different classes, income, capital, default beneficiaries. Next key provision is making sure that we do have an appointor or a principal from the start, and then that we have the ability for succession planning, whether that's by having a separate deed, dealing with it under a person's will, etc. Really important to make sure we have that appointor at all times. Next key provisions relate to income. So firstly, how are we defining income? How does the trustee have the ability to treat different types of income in different ways? And then how is the trustee able to distribute that to the beneficiaries, and who can that income go to? Similarly, with capital, we need to know, is the trustee able to make interim capital distributions, or is it only on the vesting of the trust? And again, who can that capital be distributed to? In terms of the powers, the trustee should be given comprehensive powers to make sure that they can best manage the trust assets for the benefit of the beneficiaries. And lastly, a couple of other traps. For example, if we do have a discretionary trust owning residential property, we want to make sure that we are excluding foreign beneficiaries so that the trustee doesn't get hit with the land tax surcharge. So they're just a few of the key provisions that we need to make sure we're looking out for when setting up a trust deed or reviewing one that a client may have brought in. Okay, so I've got 3 case studies for us to go through this afternoon. And the first one we have here is we have a discretionary trust that was generating income. And there was a clause within the trust deed that essentially said that if the trustee has not within a reasonable time determined how the net income of the trust is to be distributed, then the income was to go to default beneficiaries. So it doesn't specify the end of the financial year, it just refers to a reasonable time, and that's given a very vague definition. If we were to have the trustees going away on holidays from the end of June to the beginning of July, let's say the accountant recognises the end of financial year coming up, and so they prepare resolutions and send them by email, but they're not ultimately signed until the 11th of July. Looking at the terms of the trust deed, it could be argued that the reasonable time for making those distributions was when the trustees came back to Australia and signed the resolution, but that's not going to help us from a tax perspective. If we did have default beneficiaries to ensure that the trustee wasn't getting hit with the top rate of tax, it would have been much more sensible and much smarter to just specify 30 June or the end of an income year, rather than referring to this vague reasonable time concept. So that's just an example of making sure that we're specifying these concepts accurately, so there's no ability for that top rate of tax to be triggered if we are wanting to have default beneficiaries. Another case study that I've got here. So we've got a trustee that was looking to vary the terms of the trust. And so the trustees reviewed the trust deed and they found a variation power. And it was a fairly straightforward power that simply said, to the extent permitted by law and subject to this clause, the trustee may amend the terms of the trust. So the trustees thought, excellent, we've got this variation power. There's no conditions on the power. So they went and prepared a variation and signed it, thinking that it was all effective. But later on, it came to their attention that there was a separate clause within the trust deed that says that the written consent of the primary beneficiary will be required before the trustee may amend the terms of the trust. So that then posed an issue because the consent hadn't been obtained before the variation was executed. And so if we are looking at the trust deed in its whole, the argument would be that the variation wasn't effective. And so in that trust deed, we had the consent provision in clause 6.3 and the variation power in 10.1. So a bit unusual in that they were spaced out within the trust deed, but that's a really important thing to make sure that we're looking at the trust deed as a whole and not just finding the variation power, looking at that by itself and not considering whether there might be any other requirements within the trust deed. And in that case, often it wouldn't be a problem because the primary beneficiary or the person that needs to give consent is probably a related person, a family member. And so often you would just re-prepare the deed of variation, obtain the consent, and do it again that way. But in some cases, you are dealing with strict deadlines. For example, if we are trying to avoid that foreign land tax surcharge, we need to make sure that's done by 31 December. So if this were to happen in that case, and it wasn't discovered that the consent had to be obtained until the new calendar year, that would be a big issue because the variation wouldn't have been made in time. So yes, that's just a point to say that make sure you're reading the entire trust deed and checking for any requirements or conditions that may be hidden elsewhere. Third and final case study that I have. So we've got Mr. Kepler, who is the sole trustee and appointor of the Europa Trust. And Mr. Kepler is married and the new wife has a daughter who is severely disabled. Mr. Kepler has 2 adult sons from a previous marriage, but Mr. Kepler's view is that he has already provided the 2 sons with a lot of financial assistance in the past. And with this Europa Trust, he wants to benefit the wife and the disabled daughter. So within his will and his letter of wishes, he sets out these intentions for the trust to benefit the wife and the daughter. But within the trust deed, it says that upon the trustee or the appointor's death, the new trustee and appointor will become their legal personal representative. So the executor under Mr. Kepler's will. And there are also default beneficiary provisions within the trust deed, being Mr. Kepler or his children. And it specifies that children does not include stepchildren. So the disabled daughter of the wife would not be a default beneficiary. And so under Mr. Kepler's will, he appoints his wife and also his 2 adult children to be his executors. And when he passes away, the 2 adult sons realize that it was not the father's intention for them to benefit from the trust. And so obviously they're quite upset by that revelation. The issue with this is that under the terms of the trust deed, the trustees and the appointors would automatically become the executors. So that would be the wife and the 2 adult children. And those powers would need to be exercised jointly. So we would have a situation where we've got the wife and the 2 adult sons, and there's no chance that they would be cooperating or wanting to make any distributions for the benefit of the wife or the stepdaughter because they've been left out. So the trustee powers and the appointor powers wouldn't be able to be exercised because you wouldn't have that unanimous consent. And so with that, if you've got no decisions being made by the trustee, that would then go back to the default beneficiary provisions. And so the income would automatically be going to the 2 adult children anyway. So this would pose a real problem because if the 2 adult sons aren't willing to cooperate, if they sit back and do nothing, they're going to receive the income anyway as the default beneficiaries, which is entirely against the original intentions of Mr. Kepler. And so the decision-making would be paralyzed, and the only way to rectify this situation would be to have the wife apply to the Supreme Court to have the 2 sons removed as trustees, appointors, and or beneficiaries. And so that would lead to a large dispute. It would be a costly exercise. And so this is something that could have been avoided by proper succession planning. by firstly just saying that the wife on her own was to be the appointor of the trust on his death. That would have completely resolved this situation, and there would have been no right of the 2 adult sons to the income of the trust. But that's just an example as to how a poorly drafted trust deed together with poor succession planning can completely fail on a client's objectives. So just to wrap up before we get to any questions that may have come through, I hope today has perhaps clarified some of the key points and some of the key issues that can arise in terms of trust deed drafting. We do come across them so often, and it can be easy to ignore some of the provisions, but it's really important to make sure that we're addressing each of those different items to make sure we're minimising any confusion, any disputes, and any need to litigate the different issues that may arise. So I think I'll wrap up there and hand over to you, Adrian.
Thanks, Kate. Just the one question so far. If you do have other questions, feel free to send them through. But the question is, what are the requirements that determine which state a trust is settled? The address of the settlor and or the trustee. I understand trust documents supply ASIS settles trust in Queensland to avoid New South Wales stamp duty.
Yeah, I think it comes down to, I might actually defer to you on that one, Adrian. I know there's been a bit of conversation about that point.
Yeah, sure. I mean, usually it's the trustee, the address of the trustee. And there has been some changes that have come through in the New South Wales Duties Act, well, in the last 18 months, really, which would capture that sort of arrangement where you're deemed to have been settled in New South Wales anyway, particularly where there's a New South Wales registered company as trustee. So obviously New South Wales Revenue got wise of those sorts of arrangements and brought that in probably about 18 months ago. But yeah, usually it's the trustee as to where the state is. I mean, you define it within the deed as the governing jurisdiction, but there are some other legislation that can overlay and change that anyway, even if you said it was Queensland. We might, because we've got the time, we might wrap it up there. In terms of feedback, you will be receiving a feedback email. I'll ask you to take the time to complete that. It's a very quick one to complete, and there will be a question asking for any future topics. So we pretty much always do the ones that we get requests for. So feel free to request any topics that you think you'd like us to present on. And I'll close off there. Thanks, Kate, for your presentation. And I'll let you turn off the machine, Kate, with the
Sure.
Thanks, everybody, for coming.